Welcome to the Contracts of Employment and the Written Statement of Employment Particulars online presentation, produced by Halewood Advisory Services Limited. I am Susan, your online presenter. If you have any questions, please contact us by email. A contract of employment is created as soon as the employer and potential employee agree the main terms under which employment is offered, for example pay, hours of work, holiday entitlement and the nature of the work, and that offer is accepted by the potential employee. There is no requirement that the contract of employment be produced in a written form or signed by either the employer or employee. Where a dispute arises about the terms of the contract, a court or tribunal may rely on supporting information such as the original advertisement for the post and any job offer letters and any other document which appear to indicate the terms of the contract. The fact that there is no legal requirement that a contract of employment must be in writing, can, of course, lead to future disputes about what was agreed. The Employment Rights Act 1996, E.R. A 1996, makes it a statutory requirement that all employees are issued with a written statement of their principal terms and conditions of employment. Section 1 of the ERA 1996 provides that an employee must be provided with a statement of initial employment particulars within 2 months of the commencement of their employment. We would recommend that it is issued as soon as possible, as it can avoid future dispute as to what was agreed. Section 1 and 2 provide details of what must be included in the written statement. Some items must be included in the actual statement of initial employment particulars, and other details may be provided in supplementary documents, which must also be provided within the 2 months following the start of employment. An initial statement of initial employment particulars is not a contract of employment but will be treated by a court or tribunal as persuasive evidence to what the main terms of the contract are. The written statement is of course produced by the employer and can be said to be the employer's understanding of the principal terms of employment. Whilst not required by law, it is good practice for an employer to obtain written confirmation from the employee that they have received the statement. The employer's duty is to issue the statement, and the written confirmation can be used to show that the employer has complied. An employee will be treated as accepting the written statement as a true record of the agreement between employer and employee unless they dispute the contents within a reasonable period. The statement of initial employment particulars must include the name of the employer and the employee, the date employment began, the date on which the employee's period of continuous employment began, the scale and method of remuneration, the intervals that remuneration will be paid, the hours of work, terms and conditions relating to holiday entitlement and bank holidays, job title and a brief description of work to be undertaken, the place or places the employee is required to work. In respect to the following items, the statement may refer to other documents: terms and conditions relating to sickness and sick pay entitlement, details of pensions and pension schemes, provisions relating to notice to be given, whether or not the employment is subject to a collective agreement, where an employee is expected to work outside the UK, various details relating to pay and conditions, details of grievance and disciplinary procedures. There is no prescribed form that a statement of terms and conditions of employment may take, and an employer may comply with the requirement if they issue a comprehensive job offer letter complying with the requirements of Section 1 ERA 1996. Where an employer opts to issue a written contracts of employment, they must ensure it includes all the information required by Section 1 ERA 1996. Once the terms of employment have been agreed, an employer cannot unilaterally change the terms and conditions under which the employee works, unless a clause in the contract authorizes the change. If not and the change is significant, to do so could lead to a successful claim of constructive dismissal based on a fundamental breach of contract. Changing the terms and conditions under which an employee or employees are engaged is not without risk, and the only safe way is by mutual consent following meaningful consultation. If consent cannot be obtained, then the only way to go forward is to serve contractual or statutory notice on employee or employees who will not consent to the change and confirm in writing that the contract of employment under which they are currently employed will come to an end at the end of the notice period, but offer new employment on a new contract following the ending of the old contract. If they accept the new terms, then continuity of employment is preserved. If the employee does not accept the changes, the options open to them include: the employee can leave employment at the end of the notice period. An employee who has been employed for 2 years or more may decide not to accept the new contract and may lodge a claim for unfair dismissal. To defend such a claim at an employment tribunal, an employer will need to show they had good reason to make the change, that meaningful consultation took place, they acted procedurally fairly. Another option open to a disgruntled employee is to continue working under protest and lodge a claim with the ordinary civil courts claiming breach of contract. Where the terms and conditions of employment change for whatever reason, Section 4 of E.R. 1996 provides, an employee should be issued with a new statement of particulars within 1 month of the change taking place. Where an employee makes a claim to an employment tribunal, for example claiming unfair dismissal, a tribunal may make an additional award of 2 or 4 weeks' pay to the employee if the employer has failed to comply with either Section 1 or 4 of the ERA 1996. There are many reasons why either an employee or employer may wish to end the contract of employment. An employee may have an offer of a better paid job. An employer may need to end the contract due to economic circumstances, or they may be dissatisfied with the employee's performance or conduct. In this booklet, we consider how the contract of employment may be ended legally and fairly by either the employee or employer. There are a number of ways the employment contract may come to an end, the main ones being: by resignation, dismissal, by agreement. By frustration, the contract becomes impossible to perform, due to no fault of either the employee or employer. Either party will be required to giving notice to end the contract. At common law, the contract of employment may come to an end lawfully either by the employer or the employee giving the correct notice to terminate it. The contract of employment will normally specify how much notice either party must give to terminate the contract. In the event that no express notice requirements have been agreed between the parties, then the statutory minimum notice periods will apply. The statutory notice periods will also apply if the contract specifies a shorter period of notice. Statutory notice periods: 1. Where an employee has been employed for 1 month or more, and they wish to terminate their contract of employment, then the statutory minimum notice they must give is 1 week, regardless of the length of service. 2. In the event of an employer wishing to give notice to an employee, then the minimum statutory notice required to be given is calculated on the following basis. 2 a.m. Where the employee has been employed for more than 1 month but less than 2 years, 1 week's notice. 2b. Where the employee has been employed for 2 years or more than 1 week for each completed year of service up to a maximum of 12 weeks' notice. Not working notice period. Depending on the circumstances, an employer may not actually want an employee to work their notice period and might make a payment in lieu of notice or place the employee on gardening leave. Payment in lieu of notice. As the name suggests, using this approach, the employee is allowed to leave immediately and receives an appropriate payment for the period of notice that he or she is entitled to. Depending on the contractual conditions or any agreements reached, this should also include any payments for other benefits that the employee would have been entitled to during the period, such as bonuses and holiday pay. Notice may comprise a mixture of work and payment in lieu of notice, once again depending on the contractual requirements or agreements reached with the employee. The employee may start work with another employer immediately under these circumstances. Gardening leave is the term used to describe the situation that arises when an employer wishes an employee to work out his or her notice period but does not want him or her to attend work, allowing him or her to stay at home instead. The employee remains employed during the period of gardening and is entitled once again to all the benefits of his or her employment. This approach is useful if the employer wants the employee off the premises immediately, but would allow employer to call upon the employee to undertake required work during the notice. Whether or not the employer is entitled to place the employee on gardening leave will depend on the contract of employment and or any agreement made with the employee. Whilst on gardening leave, the employee will remain bound by their terms and conditions of employment. If either party to the contract terminates the contract without giving the required notice, the other party may bring a claim for breach of contract. It is unusual for an employer to bring a claim against an employee who has failed to give the minimum statutory or contractual notice and is more likely to occur where the employee held a senior position in the organization. If a claim is made, it would need to be lodged in either the county or high court dependent on the value of the claim. The employer would need to be able to quantify the value of their loss, for example the additional cost of hiring temporary staff. However, beware, it will normally be an unlawful deduction from wages, to withhold the final payment to the employee if they have failed to give notice, and if they bring a claim to an employment tribunal for the withheld monies, this may restrict your ability to recover damages for the breach in the county court. It is more common for an employee, who has not been given notice or received pay in lieu of notice, to make a claim of breach of contract, also known as wrongful dismissal. This claim would normally be lodged at an employment tribunal, but the county and high courts also have jurisdiction to hear such claims. If either party has breached the contract, then the other party may, if they so wish, terminate the contract without giving the required notice. This is of particular relevance when an employee has committed an offense that under their contract of employment is one of gross misconduct. An employee may also resign and claim constructive unfair dismissal, a form of potential unfair dismissal, if an employer has breached their contract of employment. It should be noted there is difference between wrongful dismissal and unfair dismissal. Wrongful dismissal is a claim based upon common law, and any damages awarded are based upon the contract of employment not being terminated in the correct manner. The reason for the dismissal is immaterial. The damages awarded will normally be equivalent to the pay the employee should have received during the notice period. However, in limited circumstance where the disciplinary procedure has not been followed, an employee may be awarded damages to cover the period of time it would have taken to comply with the procedure. This will normally only apply if the disciplinary procedure is contractual. Unfair dismissal is a statutory claim, based on legislation, and any award made by a tribunal will reflect the actual loss suffered by the employee as a result of the employer either not having a justifiable reason to dismiss or not following a fair procedure.